This is americasdemocrats.org, the weekly netcast for stand-up Democrats. I'm your host, Jim Cuddy. As the nation marks Constitution Day this week, legal scholar Jack Balkin of Yale University says conservative judges keep making up things that aren't in the Constitution and imagine a country that never existed. Antitrust expert Lina Khan tells us how the courts have taken away Americans' right to sue corporations. And Bill Press talks with anti-war Congresswoman Barbara Lee. Are you tired of Tea Party Republicans and Rush Limbaugh dominating the airwaves? Do you want the facts you won't get on Fox or even on CNN? Then stay tuned. Our sponsor, 21st Century Democrats, works hard to get everyday Democrats involved in returning our party to its roots and to success at the ballot box. Sit back and listen, then stand up and fight. And follow 21st Century Democrats on Facebook for all the latest progressive news. We're glad you can join us. Law professor Jack Balkin, on the anniversary of the Constitution's ratification, says the opinion of Supreme Court Justice John Roberts allowing unlimited political donations is just crazy. And we say hello to Jack Balkin, who's the Knight Professor of Constitutional Law and the First Amendment at Yale Law School. He is also the director of Yale's Knight Law and Media program and author of a recent article on how liberals can reclaim the Constitution, also author of some books as well, including Living Originalism. Jack Balkin, thanks so much for joining us today on americasdemocrats.org.
Thank you.
You are the author of the book I mentioned called Living Originalism, in which you argue that the original meaning of the Constitution is, in fact, compatible with change. Can you give us a couple of examples of what you're talking about there?
Yes, I'll give you two examples. One has to do with powers of government, and the other has to do with rights. Here's the example with powers. The framers of the Constitution during the first founding, they wanted to make sure that the federal government was strong enough and had enough powers to deal with national problems. So they put various clauses in the Constitution: the power to spend and to tax for the general welfare, and the power to regulate interstate commerce. Those parts of the Constitution were designed to deal with problems that arise later on that they had no idea were going to happen. The basic principle they set in place was that where there is a federal problem, that is a problem where states are separately incompetent to solve it, that the federal government has the power to deal with that problem. And when we got to the debate over the health care bill, that those principles were just as appropriate as they were at the time of the founding. Healthcare is a national problem. It's not a problem that individual states can solve. It requires a federal solution. It requires a national solution, and the government had a constitutional power to pass the healthcare bill. This is what conservative opponents did not understand. They did not understand that our Constitution is flexible enough to deal with national problems as they arise over time. So that's an example about federal power. Let me give you an example about rights. The second founding of Reconstruction, 14th, 13th, and 15th Amendments. The 14th Amendment says no one shall be denied the equal protection of the laws. What did they mean by equal protection of the laws? Well, they didn't specify, and that was deliberate, but they did have a basic principle, a principle against arbitrary and class legislation that picked a group of people out for special benefit or special for special limitations or special prejudice or special discrimination, and those kinds of laws were said to be contrary to the Constitution. So the principle against class legislation, no special harms, no special advantages, that principle is still with us today. It still makes sense today when you think about the question of same-sex marriage. The question of same-sex marriage is a question of whether or not when a state denies a couple the right to marry, it is imposing a special stigma on them and saying, you are not good enough. You are not as good as other people. And that violates the principle against class legislation. Whether or not anybody in 1868 knew what gay people were or knew anything about gay people or would have opposed giving rights to gay people, what they said is much more important than what their private views were.
Mm-hmm. And it seems also that a lot of folks automatically invoke religion when they get to that subject of the gay marriage thing. And that's nowhere in the Constitution in terms of something like that, right?
Well, no, the Constitution does protect religious freedom. It does protect religious liberty. It prevents an establishment of religion. These things are in the Constitution. But the point is that what you're not supposed to do is use the government in order to promote a particular religious ideology or to make everyone conform to a particular religious faith. That's the principle against establishment of religion.
You talk about the conservatism of the Tea Party and how it actually misunderstands the origins of the Constitution and imagines a country that never existed. What do you mean by that?
Well, I mean, if you look at our two foundings, the first founding of 1787, 1791, and our second founding of Reconstruction, you will notice something very interesting about the opponents of each of those foundings. The opponents of the first founding were the Anti-Federalists. The opponents of the second founding were the Southerners who were resisting the Civil Rights Revolution of the Second Reconstruction. There is an amazing similarity between the arguments that the Tea Party is making today and the opponents, not the proponents, but the opponents in both of those foundings. I'll give you examples. For the first founding, the Federalists, the people who wanted the new Constitution, they understood that the Articles of Confederation made government too weak. It couldn't do what was necessary to protect national security and protect the public. And they wanted a government that had the power to solve national problems. The Anti-Federalists didn't want a powerful government. They did not want a government that was competent to solve problems. They wanted the states to basically run the show. And if you look at Tea Party rhetoric, the argument is not the argument of the Federalists. It's the argument of the Anti-Federalists. Go to the second founding, Reconstruction. The whole point of Reconstruction was that state governments had basically denied people civil liberties. They had violated every part of the Bill of Rights. The purpose of the second founding was to guarantee equality before the law and to make sure that state governments respected basic civil liberties. Look at the Tea Party rhetoric today. The Tea Party rhetoric is not particularly interested in the national government enforcing basic civil liberties against people in the various states. What they're doing is they're taking the position of the people who lost. And this is a twisted version of American history. It's taking the views of the people who lost twice and claiming that that's the views of the framers. That is just ridiculous.
Mm-hmm. We're speaking with Jack Balkin, who's the Knight Professor of Constitutional Law and the First Amendment at Yale Law School, also director of Yale's Knight Law and Media Program and author of the book called Living Originalism. How do you think the founders would have reached or reacted rather to decisions that like Citizens United and Hobby Lobby, which seem to give individual personhood to corporations?
I don't think that the issue of corporations was the big deal. I don't think that's what Citizens United is about. I think that Hobby Lobby, I don't think it matters that Hobby Lobby is a corporation, honestly. I can tell you that the folks that draft the 14th Amendment didn't think that corporations were particularly important because they associated corporations with monopolies created by the government, and that's not the kind of corporations we have today. But I will say one thing about these cases from the standpoint of our founding principles, and it's very simple. The people who drafted the Constitution, our first founders, were very concerned about the idea that we have a Republican form of government. By Republican, they don't mean a government controlled by Republicans. They meant a representative form of government in which what people do in government is responsive to and ultimately accountable to the citizenry and not to some special cabal of people who have more resources than others. That is, they did not want our government to be hijacked by people who weren't the constituents. That is, the people that the government is responsible to are constituents. Okay? The basic problem with Citizens United and the basic problem with the McCutcheon case that comes after it is that the Roberts Court completely twisted this idea up, and they confused the constituents of government with the people who give the most money. That is, at one point, Chief Justice Roberts even refers to the people who give the most money as the constituents of the representatives. Well, that's just crazy. That's wrong. The people who are constituents of a House of Representatives person are the people who live in that person's district. The constituents of someone who runs for Senate are the person who lives in that state. And that's the basic principle that the founders wanted. They did not want our representatives to be derailed by and taken over by and distracted by other folks. That principle is still with us. That's the principle that's really at stake in Citizens United. In Hobby Lobby, the basic principle is that the government should protect people's religious freedom. But it should do so in ways that don't undermine the justified rights of other people. It has nothing to do with corporations. Whether or not Hobby Lobby was a sole proprietorship or a corporation, it wouldn't make any difference. The question is that what Hobby Lobby was trying to do was extinguish the rights of women who work for it. Mm-hmm. That was the problem in that case.
What do you think is the appropriate legalistic response, if you will, by progressives to the claim that only conservatives are true to the text of the Constitution?
I think that the response to that is that if that were true, why do conservative jurists keep making up things that aren't in the Constitution? I mean, one of the greatest disgraces is the Shelby County case that was decided a couple terms ago, in which they struck down part of the Civil Rights, the Voting Rights Act of 1965, one of the major accomplishments of the Civil Rights era. And they did so based on a theory that has absolutely no basis in the constitutional text and has no basis in the history of the Constitution, is actually contrary to the whole point of Reconstruction. I mean, that is a disgrace.
You predict, and I'll quote here, a renaissance of liberal constitutionalism in the next decade. Is the rapid judicial acceptance of same-sex marriage an example of that? And how closely do judges read the election returns?
Well, I don't want to put it in terms of judges reading the election terms, but I would put it in terms of this. The basic principle of the Constitution is that the Constitution belongs to the American public. It doesn't belong to anybody else. And that the American public protects their Constitution by taking ownership of it, mobilizing on its behalf. That the story that we're seeing with same-sex marriage is a story of Americans, both gay and straight, saying that we believe in the principle of equality in our Constitution, that it's our Constitution, and we are going to fight for it. And that's the reason why there has been a change in views about same-sex marriage over the last decade. That's the reason why judges now are coming around to the proposition that the guarantees of liberty and equality in the Constitution protect the right of same-sex marriage. But the point is that the judges wouldn't have done it if there hadn't been mobilization on behalf of ordinary citizens. That's the biggest lesson that liberals can take away from the events of the last decade, which is you want to protect your constitutional rights? Well, you mobilize on behalf of your Constitution. It belongs to you.
You know, redistricting is a state right. Voting procedures are state functions. The filibuster is merely a Senate rule. Are there any constitutional remedies for the gridlock that we see now?
Yeah, there are plenty of constitutional remedies. The biggest constitutional remedy is mobilize. You have the right in a democracy to get out there and say what you want. And if you mobilize over a period of time, the government responds to that. That is the most important constitutional remedy we have. We can talk about other remedies that are possible. Those have to do with changing the way in which the primary system works, which currently encourages all sorts of radicalism. We can change the ways in which districts are drawn. That can be done completely constitutionally. We can, I think currently the Supreme Court's interpretation of campaign finance law is wrong. That can be changed too with enough mobilization. I mean, the thing about the Constitution is you have to have faith in the ability of the procedures that it puts forth and the rights it guarantees to ultimately vindicate the rights that Americans enjoy. That is a faith that people have had from the beginning of the country to the present, when people lived in circumstances that were much worse and much more unjust and much more unequal than they are today. And we should just take heart and learn from what people before us have done, and we should carry that fight forward into the future.
Okay. Jack Balkin, Knight Professor of Constitutional Law and the First Amendment at Yale Law School, Director of Yale's Knight Law and Media Program, author of Living Originalism. Professor, thank you so much for joining us today. Would love to have you back sometime soon.
It was a pleasure. Thank you.
Thank you. And this is AmericasDemocrats.org, the weekly netcast for Stand Up Democrats. We want you to sit back and listen, but we need you to stand up and fight. Do you want to get involved and help get our party back to its roots and to success at the ballot box? You can make your contribution to Democrats for America's Future and help us keep this show going and to elect Democrats who will stand up for democratic principles. Go to americasdemocrats.org and click on Donate at the top of the page. This is americasdemocrats.org, the weekly netcast for Stand Up Democrats. A series of court decisions since the 1980s has made it virtually impossible for consumers to sue corporations. Antitrust expert Lina Khan explains the fine print that rigs the economic system against the little guy. We'll hear from her in just a moment. Right now, we turn to Jim Hightower, America's #1 populist, for his common sense commentary.
Have you noticed that the powers that be employ an entirely different standard for measuring the health of America's job market than they use for the stock market? They're currently telling us that the job market is improving, What do they mean? Simply that the economy is generating an increase in the number of jobs available for workers. But when they say the stock market is improving, they don't mean that the number of stocks available to investors is on the rise. Instead, they're measuring the price, the value of the stocks. And isn't value what really counts in both cases? As a worker, you don't merely want to know that 200,000 new jobs are on the market, but what they're worth. Do they pay living wages? Do they come with benefits? Are they just part-time and temporary? Do they include union rights? What are the working conditions, etc.? In other words, are these jobs or scams? So it's interesting that the recent news of job market improvement doesn't mention that of the 10 occupation categories projecting the greatest growth in the next 8 years, only one pays a middle-class wage. 4 pay barely above the poverty level, and 5 pay beneath it, including fast food workers, retail sales staff, health aides, and janitors. The job expected to have the highest number of openings is personal care aide, taking care of aging baby boomers in their houses or in nursing homes. The median salary of an aide is under $20,000. They enjoy no benefits, and about 40% of them must rely on food stamps and Medicaid to make ends meet. Plus, many are in the, quote, shadow economy, vulnerable to being cheated on their already miserly wages. This is Jim Hightower saying, to measure the job market by quantity with no regard for quality is to devalue workers themselves. Creating 200,000 new jobs is not a sign of economic health if each worker needs 2 or 3 of those jobs to patch together a bare-bones living.
Need an antidote to the progressive blues? Want some good news about how grassroots folks are rebelling against the corporate powers and winning? Well, here's an easy-to-swallow pill for you, the Hightower Lowdown. Hightower's monthly newsletter will give you the lowdown, even as it lifts you up. It's 4 pages a month, jam-packed with facts you can use, actions you can take, and Jim's own Texas humor, all for only $15 a year. To become a lowdowner, go to hightowerlowdown.org.
This is americasdemocrats.org, the weekly netcast for stand-up Democrats. Antitrust expert Lina Khan says the right to sue should be a fundamental conservative idea. But with help from Democrats, conservatives have virtually guaranteed that consumers can't even go to court when corporations steamroll them. And we say hello to Lina Khan with the New America Foundation, a policy analyst for the Markets, Enterprise, and Resiliency Initiative at New America Foundation, where she researches the concentration of power in America's political economy. A cum laude graduate of Williams College, she reports on agricultural, industrial, and financial markets and the laws that shape them. Lina Khan, thank you so much for joining us today on americasdemocrats.org.
Good to be here.
And we appreciate you being with us. As an expert in economic power, you've written a pretty shocking article describing how the courts have taken away Americans' rights to sue corporations. How did this happen?
So it's a really funny kind of set of circumstances where, in 1925, Congress passed this act called the Federal Arbitration Act. And what it basically said was that companies are able to, in their contracts, include something called an arbitration clause, which would mean that, if there was ever some kind of dispute, they wouldn't necessarily have to go through the courts. They'd be able to settle outside of court through an arbitration process. Arbitration works in ways differently from courts. You basically choose an arbiter that's like a private judge who's paid by the parties. A lot of the information that comes out in the case ends up staying private. So it's a completely different system than public courts. And what's happened is that through a series of Supreme Court decisions in the 1980s, the situations in which companies can use arbitration has been dramatically expanded. So originally, these arbitration clauses were pretty much just used between business partners, between business partners of more or less equal bargaining size who, got into some spat or contractual dispute and would want to settle outside of court. Now, by contrast, these arbitration clauses are inserted in almost every kind of contract. So, a contract with workers, a contract with consumers. So the people who are subjected to these clauses has been dramatically expanded.
Well, and specifically, what aspect or aspects of the law have the courts changed to the detriment of consumers and small businesses?
Yeah, so it's a funny situation where it's not so much any one law that's been changed. It's more just about how the law is now being interpreted. So starting in the 1980s, there were a series of Supreme Court decisions, three main Supreme Court decisions that really started kind of taking us down this slippery slope. So the first one was this 1983 case called Moses v. Mercury. And arbitration wasn't really the central issue at play, but the Supreme Court used its opinion to offer what was a radically novel interpretation of the Federal Arbitration Act. And Justice William Brennan, who was considered actually a liberal on the court, he ended up declaring that the Federal Arbitration Act reflected a federal policy favoring arbitration. And those four words were basically used by successive courts to just, continue expanding the ways in which this could be used. And then there were a couple of decisions the next few years that continued to accelerate this trend.
And we're speaking with Lina Khan, policy analyst for the Markets, Enterprise, and Resiliency Initiative with the New America Foundation. So it's true then, I guess, you mentioned a liberal Supreme Court justice. True that then this happened with the support of, and in some cases, the leadership of prominent liberals?
Yeah, it's really funny. When I was researching this, oftentimes you expect to find, some kind of coherent ideology or political commitment that explains, whether a law is being read in one way or another. And when it comes to arbitration, it's really just all over the board. So, yeah, in some instances you have Sandra O'Connor, is considered quite centrist or even more conservative, really coming out against arbitration being used in these ways. As we talked about, Brennan has been one person who's expanded the ways in which arbitration can be used. So, yeah, people's kind of political or ideological loyalties have been all over the map, and we've seen some really funny bedfellows kind of, work together to make this happen.
So it's a rigged system in which a corporation forces you to give up the right to sue? Is that what we're looking at?
So a court would say they're not forcing you, right, because you're signing a contract. And a lot of this really comes back to, what do we consider contracts? Originally a contract was considered, something that two parties of more or less equal bargaining power are together deciding to do. Nowadays, so many of us handily sign contracts just by, scrolling through lengthy pages of text online and just, clicking the I accept button. Is that something that we should consider a contract? It should be said in many of these instances, the companies with whom we're transacting are very dominant companies. There oftentimes aren't really viable alternatives. So, take AT&T or Verizon or some of these, pretty dominant telecom companies where, sure, if you took the time to read through their fine print and decided that it was offensive to you, you would maybe have a handful of other places where you could look. So I think the combination of that fact that oftentimes it's really dominant companies where you don't have a lot of competition, where you don't have a lot of options, and the fact that these contracts are often just thrust on us and kind of take it or leave it situations mean that oftentimes we are kind of helpless in the system, but the kind of theory and law behind it doesn't often account for that.
It sounds like to me like these contracts are null and void before the ink's even dry.
Yeah,
that's kind of sounds like where we've gone. So what's the purpose? Or just is it just smoke and mirrors that the corporations are benefiting from? Said, oh yeah, we're giving you a contract, but in the end, it doesn't really mean anything. But they forget to tell you that part.
Yeah, I think the contract does mean something insofar as, the fact that they have this fine print that says, if you are ever in a dispute with us, you can only arbitrate. It should be noted that one of the reasons why this has become more significant in the last couple years is because in 2011 and 2013, the Supreme Court ruled that not only were these arbitration clauses valid in all sorts of contracts, but that now they can be coupled with what's known as a class action ban. So class actions, as many people know, are a way for a lot of consumers or a lot of workers or a lot of individuals to band together and bring a case forward in a joint manner. And class actions have been around because oftentimes, it's financially doesn't make sense for an individual to bring a case on his own. Oftentimes there are, questions of fear where, if you're bringing a case against an employer, you feel more comfortable doing that in a group. Oftentimes, the evidence that is brought out in one case should be shared with a lot of people. So there are a lot of reasons why class actions do make a lot of sense. And what the Supreme Court has said is that now you can use both arbitration clauses and class action bans together in a way that says that if you, individual, ever have a problem with me, AT&T, or me, Comcast, or me, Goldman Sachs, the only way you'll ever be able to bring any kind of claim is on your own and in a private arbitration setting. So the entire idea of, courts being this public forum where we have all this information, where you have, a lot of individuals being able to come and band together, that as a right has been totally eviscerated in scores of contracts.
As soon as you mentioned it, the first thing I thought of was tobacco. And back in the 90s, in the big class actions against big tobacco. I mean, can you imagine an individual trying to win a case like that? I mean, it's impossible. Again, we're speaking with Lina Khan with the New America Foundation, where she serves as policy analyst for the Markets, Enterprise, and Resiliency Initiative. Let's look at this historically. If these rules and court decisions had been in effect years ago, would we have ever found out about auto safety or tobacco company lies, or even how the banks bamboozled customers?
It's a great question, and I think that's one of, for me personally, one of the most harmful things about arbitration is that oftentimes, even if, say, your arbiter is fair and, you trust him to make an even-handed decision between a company and an individual, one of the biggest harms is that a lot of the information that comes out during the arbitration proceeding ends up being private. So unlike in a court setting where, all of the evidence and all of the documentation ends up becoming public, available for everybody to see and for journalists to scrutinize and for other individuals who may have been, similarly mistreated to look at, all of that information instead is locked up in a private vault. And it makes a really big difference because, as you mentioned with the tobacco cases, the big case that the attorney generals brought and ended up getting a huge settlement, I think it was something like $200 billion settlement, that was built on the basis of scores and scores of individual cases, private cases that had been brought. So, somewhere between 1954 and 1994, individual plaintiffs filed over 800 suits against tobacco companies. They didn't end up winning any of those cases, but what that process did was brought reams and reams of internal documents into the public domain. And so, when it came time for the attorney generals to start looking into it, they had all this evidence already in front of them. So we really see through that how, private enforcement and public enforcement really work hand in hand. And so if you cripple one side of that, like arbitration clauses are now doing, you really cripple the other side of that too. It's kind of something that works in tandem, and you really need both sides to be there to have a strong kind of civil justice system.
And then originally, Lina, wasn't the idea of arbitration, essentially a good one for consumers and small businesses because it avoided the expense of litigation?
So the original idea of arbitration was never really intended to be used against consumers or workers. It was really something, so basically what happened was, in the late 1800s, early 1900s, we saw a lot more economic activity, a lot more kind of business transactions, and hence a lot more disputes. And so there's, the courts started piling up with a lot of kind of contractual disputes, and so oftentimes a small matter could take, months or years to resolve. And so in the 1920s, you saw these two New York businessmen basically start petitioning Congress to pass the Arbitration Act, and the idea being, this would allow them to bypass the courts. It's really interesting reading some of the history because you see how Congress at that time was very, very skeptical about this whole idea of, kind of bypassing the courts and installing this private justice system. They were very aware that if it was used in the wrong ways, it could end up depriving people of rights. And so you see kind of this, prolonged battle and kind of debate about, what are we doing? We need to be careful that this is implemented in the right way. And the two New York businessmen, were very emphatic that this was going to be very contained. It was going to be very limited. between basically business partners or between companies. So the idea that it could be foisted by a company on individuals was really not on the table, and something that Congress, at least in debates, was very wary about. So, it was originally good, and it still is good. Arbitration can be used in smart ways, again, even with consumers and workers. The whole question comes down to, are you willingly choosing it? So, one point that oftentimes people make is that if arbitration really was good for consumers and workers, there's no way that they wouldn't opt in. But this idea that it should be mandatory, that it should be binding and forced onto you from the second where you, sign a piece of paper or click I accept, that's what's really problematic.
Now, the right to sue and to use class actions, and this is what I find so odd. I mean, it really is a fundamental conservative ideal, is it not? I mean, basically to prevent big government and big institutions from trampling on the little guy?
Exactly. And I mean, that was one of the most fascinating things when researching this, was that in our legal tradition, our right to sue was really born of a deep skepticism of concentrated power. So, early Americans recognized that the ability to bring civil suits against, say, politically connected companies or wrongdoers would really lessen their dependency on government officials, who oftentimes were very corrupt. So the civil, right to bring a suit was really seen as something that was empowering individuals and reducing their dependence on, say, government. And even this issue now, I mean, it's a huge states' rights issue. It's a huge kind of anti-big government issue. I mean, if you let people retain the right to sue, we're going to be less dependent on, say, public enforcement. And so, I mean, it's absolutely right. It is fundamentally a very conservative ideal.
The times they are a-changing, I guess, right?
I guess so.
All right, Lina Khan, policy analyst for the Markets, Enterprise, and Resiliency Initiative with the New America Foundation, joining us today on americasdemocrats.org. Lina, thank you so much for your time. We look forward to having you back again soon.
Thank you.
All right, and this is americasdemocrats.org, the weekly netcast for Stand Up Democrats. We want you to sit back and listen, but we need you to stand up and fight. Help get our party back to its roots and to success at the ballot box. Make your contribution to Democrats for America's Future to keep this show on the air and help elect stand-up Democrats. Go to americasdemocrats.org and click on Donate at the top of the page. This is americasdemocrats.org, the weekly netcast for stand-up Democrats. And now, Bill Press and his guest, California Congresswoman Barbara Lee.
Oscar Pistorius has been found not guilty of premeditated murder, including the fact that it turns out the NFL probably, had the video of inside the elevator with Ray Rice way back in April, long before we ever saw even that second video. So lots, and the fact that campaign finance reform, the Senate likely to vote on a constitutional amendment to overturn Citizens United. Lots going on here. We've got it all covered for you, and look forward to taking your calls, hearing from you at 866-55-PRESS, on Twitter at BP Show, and on Facebook at facebook.com/Bill Press Show. Peter Ogburn and Elisa Murphy, as always.
Thank you so much for having me.
Glad you're here. Alicia Cruz on the phones, and Cyprian Bolding, of course, our videographer. President addressing the nation last night before the president even got to address the nation last night. Dick Cheney decided to do his speech first. The Republicans inviting Dick Cheney into the Senate to give them, and the Republicans in House and Senate, to give him their advice on what we should do about ISIS. Harry Reid says, "Are you kidding me?"
Taking advice from Dick Cheney on foreign policy? That's a terrifying prospect.
A terrifying prospect. I would rather take advice from foreign policy on my good friend from California, Congresswoman Barbara Lee, who has been certainly one of the leading critics of the war in Iraq, the only member of Congress, as we know, to vote against the authorization of the use of force after the attacks of September 11. She was watching the president last night, I'm sure, and she joins us on our news line this morning. Congresswoman, good morning.
Hi, good morning.
Hey,
glad to be with you, Bill.
Thank you. Good to talk with you. I want to start with a key statement of the president's last night about Congress and then get your reaction. Here he is.
I have the authority to address the threat from ISIL, but I believe we are strongest as a nation when the president and Congress work together.
So my question to you is, does he have the constitutional authority to do this without coming to Congress? And should he do it without coming to Congress?
Well, there's some question about legal authority currently. As I understand it, they're using the resolution actually that I voted against, the 2001, as the legal authority, which is quite interesting because that's what I said then, and that was that it was a blank check and it was overly broad,
right,
and could lead to perpetual war. And so their thinking is that, and others think that gives them the legal authority to do that.
Which, if I could just jump in, is kind of ironic because even the White House has said they think the authorization of the use of force needs amending because it is too broad, right?
Sure.
And now they're using it.
The president actually said he thought that should be repealed or something.
Oh, repealed, yeah.
You know,
yeah.
at the at a speech last year, I believe at the War College, it was the speech he gave. So I think that poses a real dilemma there. But I believe this is a new day. This is a new front. And the American people deserve to have their members of Congress exercise their constitutional duty and responsibility and to debate this and vote on it. And I still believe that, the plan he outlined last night, it was comprehensive. I think it was thought through and strategic, but it certainly included, and he said up front, an expansion of military strikes, and that puts us right back into a war. And I think that aspect of it especially is very troubling for me, and the American people need to know exactly what these military operations entail, what their ramifications are, what they're going to cost, and make a decision and vote.
Right, and the only way to really get that information, I think, is through a debate in Congress, right? Where you
and to lay out what all the options are. I mean, people, members may or may not vote for that, but we don't have, I don't think, enough information and enough understanding of the full ramifications of this new war.
Do you believe, Congresswoman, that U.S. airstrikes alone can defeat ISIS?
I don't believe that U.S. airstrikes alone can defeat ISIS. I don't think the administration believes that. And I don't think that is what the president's proposing. He laid out a political and diplomatic strategy, but the military option certainly is the option that the United States, as he said, was going to, well, the U.S. is leading, which, and that's what's so troubling. And I think that's why the Congress needs to be involved and needs a debate. But military strikes occurred and a war took place as it relates to Afghanistan and Iraq. Al-Qaeda, Taliban reconstituted. This is 13 years later. In another 10 years, what do we see? ISIS 2, ISIS 3. We have to be careful that we don't create a scenario now where there's more danger, more violence, and provides an opportunity for the formation of new terrorist groups. And I think that's why we have to be very careful.
Right. And on the military, you're right, the president's policy is a comprehensive one. But on the military side, if we all agree that airstrikes alone are not going to be sufficient, then on the ground portion of that, the president is saying we're going to depend on the Iraqi military and the Syrian moderate opposition and the other Sunni nations like Saudi Arabia and Jordan and the United Arab Emirates sending in troops as well. I mean, to what extent can we really count on them, right? The Iraqi military didn't do well the last time around.
The military didn't, and the government didn't. And going back to Dick Cheney and George Bush, it's because of them and the invasion and occupation and misleading the public on what was taking place in Iraq. it's because of this that ISIS was formed. I mean, ISIS was not around before.
Yeah, no.
And the Civil War and in many ways the neglect and the oppression, and the fact that Maliki didn't form an inclusive government. I mean, all of that gave rise to this.
Of course. Yeah.
And so, we have to really understand the history before we figure out how to deal with it.
Have you, as a member of Congress, have you been told, has Congress been told, any idea, you referenced this just a little earlier, Congresswoman, any idea how long this operation would last or how much it would cost?
No, and I think the president was pretty clear that it's going to take a while. I mean, he said that publicly. I talked to many officials, and including the vice president, on this. And I don't believe anyone has any idea other than the fact that this is going to be protracted. It's going to be long-term. And ISIS, of course, I agree, needs to be dismantled and actually eliminated. But how do you do that without creating more violence and more terror against people?
Or leading to, as you indicated, an ISIS 2, ISIS 3, and God knows what is down the line. What is your sense of the Congress, Congresswoman, the people that you've talked to, even before there's any official debate? Are people inclined to give the president Democrats give the president a break here, or are there serious questions people have?
I think people have serious questions, but that doesn't mean they're not going to support the president. We have our systems of checks and balances, and so those serious questions are being raised by members, as they should. But that's why I'm going to continue to push and call for a debate. Now, Congressman Jones and McGovern and I wrote to the Speaker a couple of weeks ago, and we asked the Speaker to engage in in a debate and bring forth an authorization and allow for a vote.
Are there?
We haven't heard back, but even before that letter, we sent one with, I think it was 105 members who signed my letter asking for a debate and bringing forth something to the floor, or putting forth a resolution. I think we sent that letter to the president saying that if the military strikes were going to be expanded and if we were going to engage militarily, we thought that he should put out what he wants to do in the form of an authorization.
Yeah. It's too bad. I saw Speaker Boehner at Trattoria Alberto the other night. If I had known he had your letter, I could have maybe bugged him and said, what are you going to do about Barbara Lee's letter here? So have there been any hearings scheduled on this, on ISIS, that you know of?
I know we asked Speaker Boehner to at least require the Foreign Affairs Committee to do a hearing, but we also asked for an authorization to be marked up and put forth. I believe that some of the committees are discussing it. I'm on the Appropriations Committee. We have not had a notice of a hearing. Of course, the funding issue is going to come up, and so, the CR is coming up, the continuing resolution. And so there may not be a hearing. They may do everything in the continuing resolution.
Well, that's what we've been sort of told around the White House, is that not officially, right? But it looks like that the funding the money they need, particularly for the Syrian opposition, right, would be contained in the congressional resolution, the CR, as they call it, the continuing resolution rather than the CR, so that in effect it would be almost automatic, no hearings, no debate, no nothing. They just do this and then go home.
Yeah, and that's
a chicken
troubling.
way of doing it.
That's troubling. As I understand it, that probably will come up next week. It was to come up today, and that to me is not the way you engage in a very serious operation that's going to lead to an expansion of the United States military forces, and that's what is going to happen. I mean, earlier, Bill, I supported the use of strikes to protect civilians, to prevent a genocide from taking place and protect U.S. personnel. Those were limited and targeted, and I personally said, okay, if the outcome is what is stated, then I will support that.
And
anything beyond that, that's right. And then anything beyond that, though, is an expansion of the military conflict and the U.S. involvement, and requires us to consider that, as we should under the Constitution. And it's expanding, and I'm concerned about mission creep, and I'm concerned that this could lead to another full-scale war with the United States leading. And as the president said, when he said leading, I'm, worry a little bit, because that means we're leading, and that puts a lot of responsibility on the American people.
Yeah, and it gets us into almost at least close to a perpetual state of war with no end in.
And that's what we're in right now. The president in several speeches has said we've got to end this perpetual state of war. And this is what I feared in 2001 and 2002. And when you engage in blank checks and give authorities to use force in perpetuity, this is what happens. It's very dangerous.
Well, and Congressman, I'm sure you're the last one who wants to say, I told you so, but you could almost say that right now. And I'm so glad that your voice was there in 2001, and your voice is still there today. We need you. I know you're not alone, but you're the leader there. So thanks so much for all that you're doing. Keep speaking out. You're asking the right questions, and thanks for your time this morning.
Thank you. Good talking with you, Bill.
All right, Congresswoman Barbara Lee.
Bye-bye.
Yeah, absolutely. She sees it, that this is just lots of serious questions, and the only way to get answers to those questions is to have a full congressional debate. And that is not being anti-Obama. That's just being pro-America, seems to me. Have a full congressional debate, gets the answers to these.
That's all for americasdemocrats.org. Thank you to all who made today's show possible. Jack Balkin, Lina Khan, and the entire Bill Press team. And thank you for listening. If you liked what you heard, please get involved in our efforts to keep this show going and to elect Democrats who are bringing the party back to its roots. Go to americasdemocrats.org and click on Donate at the top of the page. And be sure to find 21st Century Democrats on Facebook. For americasdemocrats.org, I'm your host, Jim Cuddy. We want you to sit back and listen, but we need you to stand up and fight. Join us, support the show, and help elect Democrats who will stand up for democratic principles with your contribution today. Go to americasdemocrats.org and click on Donate.